It's always a pleasure to create content on this platform. For my returning subscribers, I thank you. Thank you for always stopping by to check what is new on the channel. And for those who is watching me for the first time, you're most welcome. Please do consider subscribing to the channel. This is Lawyers Infohub, a platform where we share legal tips, legal concepts, we talk about law practice, ways to excel as a lawyer, a law student, also bringing people to discuss their own experience to help you become the best you can ever be. So today we're looking at the decision of Decree Nisi. Now, in matrimonial proceedings, which is fondly known as the divorce proceedings, when the petitioner have filed the petition, the respondent has responded. Even if the respondent has not responded, the period given by the court for response has elapsed. The petitioner is made to file the statutory forms. And when the statutory forms have been filed, if there is a child of the marriage, the court will ask for parties to go sit down and have a compulsory conference towards the welfare of the child. So parties should sit down, talk about how they will take care of the child and all of that, and report back to the court. Where there is no child and there are properties, the same the court also order for parties to sit down and discuss how they will handle or manage the properties. Where there are neither properties or children, and the petitioner has maybe filed his or her answer, or does not even file, the petitioner will still proceed and prove the petition. And when the petition is proved, the court will then give judgment one way or the other. Now, after the court has given judgment and has declared the marriage broken, upon the proof of the grounds stated in section 15, the court will then make an order nisi, which is like an interim order stating that the marriage has been dissolved. This order nisi is supposed to last for 3 months. After the 3 months, if there are no intervening issues, there are no applications, nothing to make the court to look back on the decree order nisi, the order will not become absolute. When it becomes absolute, the marriage has finally been dissolved, finally, permanently. Now, when an order nisi has been made, when the court gives its judgment, there are three factors that can cause the rescission of an order nisi. There are three issues that can make the court look back and say, wow, I don't think this nisi should be made absolute. Now, so one of the issues is where parties have reconciled. So after the court has given its judgment and an order nisi has been made, and the parties by themselves have reconciled, then an expert application can be filed to the court, wherein in the affidavit these facts with respect to the reconciliation will be made known to the court, and that expert application will be served on the other party, who comes to court through his counsel or by themselves to confirm that, yes, my lord, we have settled. So when there is reconciliation, is one instance where there will be rescission of order nisi. The second one is on grounds of miscarriage of justice. A court that made the order nisi, which has not become absolute, if the court is satisfied that there has been a miscarriage of justice by reason of fraud, suppression of evidence by any of the parties, then the court has the power to rescind the decree order nisi made. It may also order that the proceedings be reheard. If there is an evidence that there was fraud, something mixed up, we have seen instances where people fake, you know, issue of divorce in terms of the petitioner may not be present in court and someone else is come to say, I'm a petitioner. There are circumstances that, that suppressed and all of that. Maybe their properties, and they say it's two rather than four. There are some things that could have, that could have been suppressed. And these facts come to light the court may order for the proceedings to be reheard. A party to the proceedings who applies for this rescission under the ground of miscarriage of justice shall cause the application to be served on the other party. So when the court have made a judgment and there are facts comes to light, the court, the party who is alleging the fraud, suppression of facts, will make an application to the court for the matter to be reheard or to let the court know the new issues that have arisen or the facts that were suppressed or the fraud that was, being alleged. Then you have to also serve that application on the other party, be it the appel, the petitioner or the respondent. So under the ground of miscarriage of justice, an order NISA may be rescinded. In terms of what this means is the court will say, okay, I do not think this order I made was proper. I will look at it again. Now, rescission in consequence of intervention. When there is an intervention after a decree NISA has been made and it is proved that the petitioner has been guilty of collusion. If you have watched any of my videos on matrimonial causes on issue of trial and all that, I've mentioned that the question on issue of collusion and connivance is usually asked if in examination in chief of a petition to say, did you connive, did you collude to bring this matrimonial proceedings? It is a very important question. And if there's an evidence that there was collusion with intent to cause perversion of justice, or that the material facts that ought to be brought before the court were not brought, then the decree may be rescinded by the court. So once there is a proof that the petitioner is guilty of collusion, connivance, it's a ground under which the court, if satisfied, can rescind the order NISA that has been granted. Now, it is also important to know that where the order, the timeline has elapsed and the order NISA becomes order absolute, it brings the marriage to an end. But it doesn't also stop those parties that their marriage has broken down or they were officially divorced by the court to remarry again. So order absolute does not stop parties to remarry. But what order absolute does is it shows we have come to the end of these proceedings and the order for divorce earlier made is now permanent. So we have stated the three instances where the court can rescind an order NISA. We talked about where the parties have reconciled. We talked about the ground of miscarriage of justice, and we talked about intervention, where there is perversion of justice. And if these facts can be brought to the court can look at it and rescind the order NISA earlier made. Thank you for sitting put to listen to what I'm saying in today's class. If you have any question, comment, contribution, please drop it on the comment section. In this channel, we have over 100 videos that will be very beneficial to you. So take your time, go through the channel. We have taught various areas of law that will be beneficial to you as a practicing lawyer, in-house counsel, law student. We believe that knowledge is the light that chases away the ignorance, the darkness of ignorance. So we believe that we are contributing our own quota to the growth of legal education, advancement of legal education in Nigeria and Africa. So we urge you to check our channel for other content, wonderful videos that be of great help to you. Do take care and know that you can always be the best that you desire to be. So today, just hope you understood the instances where the court can rescind a decree NISA. Do take care of yourself. Bye.